AI and environmental marketing are hot topics, but our panel is going to talk about the other hot topics, including in the United States, influencer marketing, which is a really hot topic. Fortunately, we're going to skip this slide. So in the US, there are many hot topics, including dark patterns, price advertising, children's advertising, and privacy, as explained in the D&G alert if you want to access our QR code there. But unfortunately, like my other panelists, there are several hot topics in our country, but we don't have time to speak about all of them today. So I'm going to focus on what I find the most interesting, influencer marketing. It's also likely a hot topic for many of the countries in this room. So the Federal Trade Commission's endorsement guide set forth the rules for influencer marketing in the United States, including what is an endorsement and how to make a disclosure. And after 14 years, the FTC finally updated its endorsement guides in 2023. And some of the notable changes are changes to the definition of an endorser to now include virtual and pet influencers, so it doesn't just have to be a human being. There's additional guidance on what is a material connection and how to disclose. New section on child-directed endorsements, as special care must be taken when including endorsements directed to children, and making clear that advertisers, agencies, and influencers can all be held liable for influencers' endorsements. And the most important changes really focus on how to make a social media disclosure, as the FTC wants disclosures to be unavoidable. So what does this mean? Well, that means disclosures must be above the More button, and if an endorsement is made in the visual, disclosure should be made in the visual. If the endorsement is made in the audio, disclosure should be made in the audio. And if endorsement is made in both, disclosure should be made in both the visual and the audio. And the built-in tools on social media platforms are likely insufficient. The FTC also provided guidance on how to make an effective social media disclosure. Starting a post with hashtag ad, paid ad, advertising would likely be sufficient. However, commonly used disclosures such as hashtag contest, hashtag sweepstakes, hashtag sponsored, and promotion may be ambiguous without a brand name. So some of us thought that the FTC's recent guidance, at least the one I just discussed, may be more of a best practice, but shortly thereafter, the FTC announced that it sent warning letters to 2 trade associations and 12 influencers claiming that their influencer posts were insufficient. Now, some of these posts didn't include any disclosure that the influencer was connected to the association and did not identify the sponsor of the posts. Some of the posts included a disclosure in the caption and description, but not on screen or verbally in the video. And some influencers relied on the Instagram's paid partnership disclosure tool, which we already told you the FTC said was insufficient. So if we look at the first example, was part of these warning letters, it doesn't really look that bad to me. It says we partnered with American Beverage Association and ad. But according to the FTC, these disclosures were below the More button. The video itself did not include any disclosures. And because the influencers made endorsements in both the audio and the visual, this disclosure should have been in both. So the lessons from these warning letters is that if you're engaging in influencer marketing in the United States right now, you need to make sure you're complying with the FTC's updated guidance, because influencer marketing is not just a hot topic with us, but it's a hot topic with the FTC right now. So I'm going to turn it over to José, as influencer marketing is also a hot topic in Mexico, as is ambush marketing.
Thank you very much, Allison. Well, I'm José Antonio Arochi from Arochi and Lindner in Mexico. I'm going to tell you a little bit about how's the landscape on Mexico authorities regarding advertising. And like Allison mentioned, I'm going to talk a little bit about ambush marketing, some cases that we have of ambush marketing in Mexico. It's going to be a big thing in Mexico in 2 years, ambush marketing, due to the World Cup that we're going to have in Mexico, the United States, and Canada. So it's going to be interesting to see how enforcement is being done in Mexico, and then if we have clients that have presence in the 3 jurisdictions, how we're going to advise our clients on each of how you have to do your campaigns in a day-by-day. So the question is there any regulation in Mexico regarding ambush marketing? So the thing is, in Mexico, we don't have a specific law on ambush marketing, but we have different authorities. Different to the United States, that it's just the FTC. In Mexico, you have Profeco, which is the Mexican FTC. Then you have COFEPRIS, which is the Mexican FDA. You would say, why FDA? Well, for certain products that are established in the Mexican health law, you need publicity and you need a permit from the Mexican FDA. So there's enforcement from the Mexican FDA. Then you have INPI and INDAUTOR, which is the IP and copyright offices. There's unlawful competition issues. There is a law established indigenous traditions, and there's advertising issues there, so the copyright enforces those issues. Then you have the Mexican Attorney General's Office, civil courts, COFECE, which is the Antitrust Commission, and CONAR. It's a sad news. I was talking to Jeff about it, but CONAR, after this year, is not going to be present in Mexico anymore. So we are trying to see what we're going to do, but we need a auto-regulatory body, and the problem is that due to government issues, there's not going to be more. They were giving money to the CONAR, and CONAR doesn't have any basis to stay in Mexico. So I think let's see what happens. So like I was mentioning, COFEPRIS and Profeco are empowered to regulate advertising and consumer protection aspects. These authorities have the power to initiate different complaints. It's a little bit complicated. Profeco doesn't have the teeth that FTC has in the United States. The hands, if it's not a trending topic, if it's not something that everybody knows day by day, Profeco will not act. But there is things that are starting to get very, very important for Profeco, like ambush marketing. So just so you know a little bit, COFEPRIS and Profeco, from all the authorities that I was telling you, are the big enforcers regarding advertising matters. Then, obviously, the ambush marketing, we all know what is ambush marketing, but at the end, ambush marketing is events that are coming into effect in our jurisdictions, and companies that are not, in a way, official sponsors use the event and maybe the sport to try to get an advantage. So at the end, you can try to file a complaint before Profeco for misleading advertising due to ambush marketing, or before the Mexican PTO for unlawful competition. So at the end, what we as lawyers in Mexico, we have our job is to try to give the best strategy to our clients. And that's the good thing about Mexico. We have a lot of options, and it's not just Profeco, which is the Mexican FTC. This is a precedent, in 2002, Pepsi against FIFA. It's been the biggest ambush marketing case in Mexico. So here you see David Beckham, Roberto Carlos, and you see a sumo wrestler. Obviously, what happens here is the World Cup was in Korea and in Japan. The Pepsi is not the official sponsor, it's Coca-Cola for sure. And you have the sumo wrestler, obviously the association with the wrestler, with the country, Japan and Korea, gives the consumer the belief that Pepsi is an official sponsor. You have to understand that in Mexico, advertising is not well known in courts, so you have to educate the authorities. This case was something that you would have to go with a judge to tell him a little bit about what happens. This case got into the appellate court. So in Mexico, you file your complaint before the administrative authority, then you go with the judicial authority, then you have the appellate court, and then if there's any constitutional grounds, you can bring it up to the Supreme Court. That's for every type of case, but advertising cases, there's just one that was about to get to the Supreme Court, which was this case, but it came down. So the last instance was the appellate court. Then in 2014, there was an issue with the Mexican national soccer team. So Mexican shirt is green, la verde. That's our team, El Tri, and the majority of or all of the Mexican teams in the local league used the green color and there was a complaint before the Mexican FTC regarding ambush. At the end, it wasn't. It didn't get to any type of grounds. There was more like a verbal agreement. But just so you know a little bit of how things are going regarding ambush in Mexico. This is an interesting case. Adrian and myself, my colleague, we did all of the clearance for Samsung regarding the use of a very big TV in an area where there was a lot of people, but obviously Samsung was not the official sponsor. It was Hisense. So at the end, we got a letter from Hisense saying you are not the official sponsor for the World Cup, so you cannot be promoting or doing activities that have a relationship with the World Cup. And this was in 2022 when it was Qatar. So just so you know a little bit, or you have a little bit of understanding what's happening in Mexican jurisdiction regarding ambush marketing. And at the end, before I start with the Mexico influencer guideline, it's gonna be very interesting to see how the Mexican FTC reacts to the World Cup. I would assume, or I would try to bring or have an area that regulates or makes more enforcement regarding ambush marketing, because there's gonna be companies, there's gonna be little stores, everybody that is gonna take advantage regarding ambush marketing in Mexico. Like, you know, football or soccer for us is a religion, and it's gonna be a big thing in Mexico. Unfortunately, we have very few games, and the majority are here in the United States, but it's gonna be something interesting for us attorneys that do advertising law to see what happens regarding the enforcement, because it's not just gonna be the FTC, it's gonna be even COFEPRIS, because there's gonna be products that are gonna be associated with health law issues that in a way will have to be referred to something regarding ambush, and the Mexican FDA will come into effect, and the Mexican PTO will be very interesting to see how they resolve unlawful competition issues. So it's gonna be interesting to do all the clearance for all of our client campaigns before the World Cup starts, and we have to be very adjusted to what the ambush marketing guidelines established by FIFA are, if they're being taken in consideration. So that's for ambush marketing. I wanted to put it like a hot topic because it's gonna be a big thing in the next 2 years. And then the Mexico influencer guideline is something very important. Last year, the influencer guideline came to effect. Mexican Profeco says that it's not binding, but obviously it's binding. We have a big case with a big influencer saying that a battery can be charged in 10 minutes, which obviously you can't charge a battery in 10 minutes. So the case is big. Now the case, they're suing the influencer, they're suing the Chinese company, and they're suing the agency. The influencer guideline just establishes what you have to say or what you have to mention regarding what you are publicizing in a day by day. So at the end, like I mentioned, they say it's not a binding guide, but obviously it's a binding guide because the guide refers to the Article 32 of the Consumer Protection Law. And this is election year, so things have calmed down a little bit marketing-wise and influencer-wise. But I think after elections, we're gonna start having a little bit more of enforcement regarding this type of matters. So these are the obvious recommendations for our clients in a day-by-day for influencers in publicity. And well, I'll turn it to Turkey.
Hi everyone, thank you very much for joining us today. I will be talking about the dark pattern practice under Turkish law. Amongst others, I choose this topic because I really like reviewing the decisions about that. The term dark pattern sounds like something evil, and actually which is evil in some occasions. The Turkish, so the term dark pattern is quite recent in Turkey, but the concept is not recent. We always had the concept of unfair commercial practice in our regulation, and the term is quite broad, and it also covers any actions that intends to manipulate the decision-making process of the consumer or alter the decision of the consumer in favor of the provider or the seller. Here is the definition just used under the law. So recently we see that the advertising board also started to use dark pattern. Actually, they invented a Turkish word which it sounds even more evil actually. The exact English translation will be something like evil projects or something like that. But I mean, yes, here there are 3 decisions which I would like to discuss, and these are typical examples of dark patterns actually. In the first one, it relates to a Turkish GSM operator. It is the leading actually GSM operator in Turkey. Here we see that the advertiser just offers consumers different options, but makes it they make easier to select the more benefitable option for them. Actually, they are manipulating the consumers to choose the annual subscription as opposed to a monthly subscription. So the office, of course, considered that this is a dark pattern because they force consumers to enforce a contract that they would not normally opt to. In the second one, a similar pattern we see. This is about a local platform, a TV platform, a streaming platform, so-called Blue TV. Here, again, we see that they're offering some pre-selected options to consumers. And you'll see that the pre-selected options and as best value is actually the best value for the platform itself, not for the consumer. So this is also considered as a dark pattern because it forced the consumer to execute a contract for a longer term as opposed to a shorter one. And the last one is from Microsoft. Here, a similar pattern, but this time the advertiser offers the upgraded version, although there is also a cheaper option of that product. So here it says that the advertiser makes it harder to keep the current version and somehow force the consumer to upgrade the product. So this is also considered as a dark pattern. So as you can see, the office is quite busy with these type of decisions. We don't have any decision about auto renewal yet, but we know that they are. It is being discussed. We had some informal chat with the advertising board, and they are considering if auto renewal is per se a dark pattern or not. And we'll see what will be their decision. I think we will have more decisions in a couple of months, and I will be happy to report it. And thank you very much. This is all for me from Turkey.
Well, now talking about Luxembourg, I've chosen to talk about project placement because it's also a hot topic regarding transparency issue. So as you said, as you know, project placement can be defined as marketing method that involves strategically and deliberately placing products or services in movie, TV show, and other types of non-advertising media. The goal is to showcase a product or a brand in a positive light by integrating it seamlessly into the content, creating a subliminal connection with the audience. It can be direct or indirect, especially when a company's logo or branding appears within a scene without actually featuring its product or services. Well, product placement, and this is some summary of Luxembourg regulation, which is really in line with EU regulation. So product placement is legal in Europe. It must, however, comply with 3 formal conditions. First, media service provider must maintain their responsibility and editorial independence with regard to content without any external influence. Second, specific promotional reference to goods or services that directly encourage their audience to buy are not allowed. And third, the product in question must not receive excessive attention and importance. It must therefore be clearly said of the existence of product placement either at the beginning or at the end of the broadcast. Otherwise, it turns to be suspicious advertising, which is prohibited as it misleads the public. So in Luxembourg, we have a specific authority, which is called ALIA, Authority for Independent Audiovisual, which is in charge of monitoring program broadcast by audiovisual media services and handling claims. Well, to determine whether a product placement is legally done, there are two main criteria to analyze. First, are there been payment or other consideration to the product placement? And secondly, what is the importance of the presence of the brand or the product, and whether this presence unjustifiably highlight the brand or the products. So I've chosen three recent decisions. The first one is about a TV show. It's a Dutch TV show, but it was broadcast in Luxembourg, where there were two candidates dressed up, as you can see, as a bottle of Moutarde champagne, and had to open a real bottle of champagne during the show. It was clearly suspicious advertising due to a repetitive and excessive presence of the product. It appeared several times on a large part of the screen without being justified by the needs of the game. In the second example, this is a series called Capitani, which was broadcast on Netflix, and the whole story took place in Luxembourg, and two issues were analyzed by our authority. First, a short sequence of around 3 seconds during which a close-up of our edition of our main newspaper called Luxembourg-Gewort, right here, was visible. This appearance was clearly justified for dramaturgical reason, given that the title of the newspaper dealt with the death of a character of the series. The aim here was to create a real-life setting for a story set in Luxembourg. It was not considered as product placement nor suspicious advertising. The second issue relates to the real radio frequency of the Luxembourg main radio, RTL radio. It's the first one. And here the frequency was shown for around 9 seconds and was justified as in the first example with the newspaper. And the third decision we have, it was about on-demand video services in relation with the broadcast of a humoristic show. There were two issues in the episode. The first one, it was the presence of a Corona beer where the two main characters made some jokes on the similarity between the brown beer and COVID. Also, it was not really humoristic. The beer brown appeared only once in the sketch, and it was not overly emphasized despite occupying only a small part of the screen. On the second issue, there were prominent on-screen reference to Post-Luxembourg brand, which is our main service for post and media, where the main character is provided while vehicles, products and services of the Brown Post visibly displaying the Post Brown logo. There was here no editorial reason to do so, so our authority found the presence of the brown repetitive and excessive. It was contrary to law and was considered as product placement. So that's it for Luxembourg.
And no disclosure was required? No disclosure.
Well, as you can expect from an EU member state called Germany, there are numerous regulations covering almost every legally tangible situation of a human's life. And if it's not yet regulated, you can be sure, and don't blink twice, it will be shortly. I will be talking about just a few situations of our everyday life and how these are regulated to enhance the consumer's awareness when they're ordering something online and to protect them from, I'd carefully say, overambitious online shops. The first thing to talk about is the order button, which we see when ordering something from a web shop. There are many ways to indicate what it is, but in Germany there is only one solution. The button must be designated with the wonderful German words zahlungspflichtig bestellen. Order now with the obligation to pay, which I must say is one of the few things where German is very short as compared to the English version. Usually it's the other way around. And nothing else should be in this button. Comparable wording is allowed provided it is similarly specific. This would, for instance, exclude wordings like subscribe now or order now, because German consumers might not understand that they would actually have to pay for something they are ordering. Very popular, but not allowed is the free trial continues for a fee. And the pay now by credit card or PayPal, for example, if other payment methods are available. No harm, however, if all other payment methods are listed next to each other the same way. The sanction for non-compliance is simple: the contract is not valid, which is a pity for the seller because oftentimes consumers only realize months later that they do not have to have a valid contract and might then decide to reverse it. The second regulation to discuss is not only for online contracts, but applies generally for subscriptions, which means for all kinds of repetitious supplies and services. Very simple regulation. The duration of such contracts cannot surpass 2 years, and the notice period for termination is only 1 month. If either of the two prohibitions is not complied with, the sanction is that the clause is not valid, which would lead to a contract that can be terminated at any time. Thanks, by the way, to the mobile phone companies that were indeed pushing it a bit over the edge, and they are more or less responsible for that kind of regulation, I assume. They are also most likely responsible for the next regulation I wanted to talk about, auto renewal. The only auto renewal clause that is allowed is a clause that extends the contract for an indefinite period of time, at the same time with the right to terminate the contract at any time with a notice period of only 1 month. The sanction for non-compliance here is the invalidity of the clause, with the consequences that the initial runtime designates the end of the contract. So, and the fourth and final regulation is the termination button that has been introduced recently, it's the online conclusion of contracts. If the online conclusion of contracts is made possible, but the important thing here to note is that it does not have to be the specific contract that you need to terminate online, but if generally the seller offers the conclusion online, which is not always the case, of course, then there has to be a solution to terminate all the contracts that have been maybe even made in a brick and mortar store. So many people don't know that, but they have to rely on that and can actually go. So I've put the implementation features here, and there's not much more to state, except maybe one case that I put here. I think it was the first court case actually. A merchant requested a password, and the court said no, for the reasons I put here. So it should be made easy for the consumer to terminate the contract without having to look for the password. Which, if they comply with the rules, there should be so many different passwords that they have to look it up. And here the court said there must be other parameters available, like the name and maybe the number of the contract, which is probably similar to the password. They have to look it up anyway. But that's how the court decided, and it should be made simple. So then I have another price indication ordinance I wanted to talk about, but I've been made aware that we are running out of time, so I'll pass over. But if you have questions about this and you find it on the slides, you can just talk to me after the session. Thank you very much.
Hello again from me. So today I will speak about the deal that really has marked the advertising space of Bosnia and Herzegovina this January. So it's a very recent thing in the advertising space in Bosnia and Herzegovina. Unfortunately, we're a slower market and not that regulated, so we don't really have a lot of case studies to explain and talk about, but this one has really shaken the advertising space in Bosnia. So to be able to explain everything, I will just give you a little bit of context so you're able to understand why this is very important in Bosnia. So Bosnia and Herzegovina is a country in the southeast of Europe. We are in the Western Balkan, and our surrounding countries are Croatia, Serbia, and Montenegro. So unfortunately, in 1992, we had a war that took place for 3.5 years and ended in 1995. And the war was followed after the independence from Bosnia and Herzegovina and after it became a recognized state by the UN. So to end the war in December 1995, there was a Dayton Peace Agreement. So it has a little bit of a misleading name because it was agreed in Dayton, but actually it was signed in Paris in December 1995. And one of the countries that was witness to the Dayton Peace Agreement was the UK, and this is very important to memorize for the following of the presentation. So following the war, we have the structure in Bosnia and Herzegovina. It now consists of two entities, so two territorial entities, the Federation of Bosnia and Herzegovina, Republika Srpska, and the small district, well, obviously influenced by the US. We have the Brčko district, which is owned by entities, Federation and Republika Srpska. So what actually happened in Bosnia? So there is a celebration of 9th of January in Bosnia and Herzegovina, which is deemed as a national day of Republika Srpska. And there is 3 times there was a decision of the Constitutional Court of Bosnia and Herzegovina that 9th of January celebration is unconstitutional. The reason why it's unconstitutional is because proclaimed, so self-proclaimed independence of the Republic of Serbian people, which happened on 9th of January 1992, so 3 months before even the independence of Bosnia and Herzegovina from Yugoslavia. Also, it marks the patron saint day of Republika Srpska, and obviously because Bosnia and Herzegovina is a multi-ethnic society, this is against the diversity and multi-ethnic society. So this celebration of 9th of January is unconstitutional and illegal under the Bosnian law, according to the Constitutional Court of Bosnia and Herzegovina. So this is the context to be able to understand what actually happened in the marketing world in Bosnia and Herzegovina this January. So what happened? Although it's unconstitutional, each year we have 9th of January celebration. And this year we had another one, the entity of Republika Srpska, they had a public call where they awarded a public contract to a marketing agency to organize media campaigns and also to organize the full celebration of the National Day of Republika Srpska. The total deal is around 350,000 USD, which is for Bosnian standards a big deal. So what happened? Well, this wasn't sanctioned in Bosnia and Herzegovina. It was actually sanctioned by the UK. And I will say now how this was sanctioned by the UK. So, as I said, UK is a witness to the Dayton Peace Agreement, and under the broader scope of the anti-money laundering regulation of the UK, there is a specific act called Bosnia and Herzegovina Sanctions EU Exit Regulation 2020, according to which UK can sanction any entity or any person that undermines the constitutional order of Bosnia and Herzegovina. So purely domestic deal ended up on UK sanction list. So this is very important to know because, as His Excellency UK Ambassador Julian Riley said, United Kingdom enables sanctions against those who undermine or threaten the sovereignty, territorial integrity, and international prosperity or constitutional order of Bosnia and Herzegovina. And Mania, so the agency who was awarded this contract, ended up on the sanction list, and because of it, the final consequence of the sanctions were asset freeze and the sanctions prevent Mania, the agency, for doing any business in the UK. So from receiving any business from the UK or any business from the UK can't actually engage in anything with Mania. So I guess because Mania had a lot of contracts with either British Embassy or USAID or other international organizations, they will definitely feel the consequences of the sanction list. So what is the lesson that we've learned in the Bosnian market this January 2024 is that this action is to serve as a warning letter to everybody else, and that it's very important to actually find balance between what the contractual and creative business freedom is and what's actually the legal landscape. So thank you very much.
Too much in the corner. Okay, thank you. I'm the last one in this session. And if you have looked at the pattern in what all these international cases we've been discussing, is that somehow within the advertising cases, we are looking at not just what the advertising is there, but what it doesn't, somehow what it's refraining from saying, which is becoming problematic. And Colombia certainly is not outside of that pattern. And we're going to present 3 cases which are interesting. The first one deals with financial information. That is, usually the banks the customer goes to the bank and the bank tells them exactly what is their interest rate, how he's got to pay, they have to sign these contracts. But with all the fintech processes, there's been a lot of startups that are not exactly banks, but are providing loans. And they are very short-term loans by small amounts. You say $50, $60, like you're in the restaurant, your debit card falls short, your date is going to look at you nasty, and you have a way out, bam, you get the money back into, and you can make the payment. The problem with those, the advertising with those systems is that all the information that is usually printed and presented to the customer is not there. It's just basically you go into your app, very soon you ask for an application, they check online, they know if you're creditworthy, and in 1 minute you have the money in your account and you can pay the bill in the restaurant. And suddenly the customers start to receive a lot of excessive, or what they believe was excessive, demands for payment in short terms, which we're not really aware. They just want to get out of the hurdle of somehow making the consumption, and boom, they got a major bill which was in excess of what they were expecting, and they requested the Superintendency of Finance to intervene. And the Superintendency of Finance said, sorry, I'm not responsible for this. I mean, they're not a bank. I mean, they just gave you a loan, but they're not subjected to the same regulation as banks and financial institutions. So the Superintendency of Industry and Commerce intervened and said, okay, well, here I'm available, yes, this is a consumption process. You should have clear and present disclosures about what is it that you're going to have to pay, but the whole purpose of basically of this is, look, there's not a lot of time to make this decision, to go and read all the disclaimers of the process. Should this be there? These are very small potato perception, so that was the defense. Nonetheless, the superintendency went and said, no, you have to be clear with your customer, you have to tell them what's got to pay, when it's got to pay it, bam, they slammed it with a sanction. So there's this other one which is interesting. It is, I will call it a questioning of common sense, or maybe not, and that is this advertising in which there was this orange juice made of oranges, actually. I mean, it was not processed, it was not concentrated, it was squeezed and put into a jar. It's just that it was heated slightly to make it last longer, but it didn't have any conservatives or anything. It was not pasteurized. And it says fresh. And you got a complaint that it says that fresh is not fresh. So we went into discussion of what is fresh. Fresh is like 1 minute, 2 minutes, 1 hour, 2 hours. How long does it have to last? And there's no definition. I mean, not by the dictionary, no by any codex of alimentary products of what is exactly fresh. So they get into this discussion of what, if they have to explain to the customer in the packaging all the process of how is, I mean, the orange is squeezed by a machine, doesn't got to be peeled. I mean, what are we talking about? And it was one of those troublesome issues in which the manufacturer was claiming, look, I'm not making anything false. This is fresh. This is taken out of the fruit. I'm not adding anything, not even water. And they said, no, because basically you heated it a little bit, it's no longer fresh. So, bam, it's a sanction. And now we have a situation which is a non-regulated item. It's totally new. Vapors are big among adolescents. I guess the usual consumers of cigarettes like their products. They don't want to go to a vaping thing unless it looks more, I don't know, fancy. But the issue is there was no restriction, there was no prohibition, it was not tobacco. So the regulation about tobacco did not apply to vapors. Nonetheless, obviously parents were concerned, consumption regulations around it were tricky because it was deemed, look, this is kind of tobacco and alcohol, this is a sort of dangerous for consumers, it must be regulated, but it's not. So the vapor importers and commercializers were saying, look, this is a non-regulated product, you cannot come to me and tell them how I have to market it, because basically the law says nothing about it. And we have a constitutional principle whereby whatever is not regulated, it's not regulated. I mean, basically all what you only have to follow precise regulations, but what is not regulated is somehow free for interpretation. Nonetheless, the superintendency, again, getting to the middle of the process and said, no, this is complicated, we don't like it, but we have to find a way around it. So they started to look for, around the edges, way to put the vapors into control. They said, okay, well, you know it's got nicotine salts, which is not exactly the same as nicotine, but there's something that you should let the consumers know that there's an addictive compound on it. So it will be interesting if you mention that, you know, that's relevant. And then they again said, well, you know, that's one of the issues that you have to put it that could be harmful for your health. Eventually, we don't know exactly yet that's going to be harmful because there are not that many studies, but we believe that it is, as it's closely associated with the smoking, and smoking is not exactly a health activity, so you have to say something about it. And then they also look for another angle, that is the warranty. You're not saying anything about the warranty, and because warranties are implicit in every possible product, hey, there should be something about it, so you also have to put labels onto that. And if that was not enough, they also came and said, like, well, you know, terms and conditions about the why you are presenting these products are not clear enough either. So we want you to know that we're on top of you. So come to us, do a joint meeting, because we're going to keep looking for all these angles to make your life difficult, even if you're not regulated. So finally, well, they, as they say, surrender to all this regulatory process, and in the process of trying to come out with new advertising guidelines about how these products shall be marketed, even though we still do not have regulation about it. So, thank you very much. That's it.
So despite the technical difficulties, we still have about 8 minutes for questions if anybody has one.
Hi. This is a question for the whole panel. I read today that the U.S. is in the process of banning TikTok for some security reasons. So I would like to ask, Allison, if you expect to be any impact on the present law, and the rest of the panel, if you expect your jurisdictions to take some similar measures after the U.S. if it does happen.
Here, you know what? Can you repeat the question? Sorry.
I was asking about, I saw that the US is apparently in the process of banning TikTok due to some security concerns. And so I want to ask if you expect any impact on the advertising regulation, and the rest of the panel, if you expect your jurisdiction to take some similar measures or anything if it is eventually banned in the US.
So I have not seen today's latest news because I was busy preparing for this. So what's the latest with TikTok?
It passed the House.
House passed it?
Yes.
Oh.
It's going to the Senate.
Wow, it's going to Senate. Wow, banning TikTok.
Yeah.
This is what you miss when you go to. This is what you miss when you go to a seminar. I'm surprised because that's going to have a huge impact on influencer marketing in the United States, especially if you're targeting teenagers. That's where they all are, and 20-year-olds. They're not on Facebook. They're not on Twitter. So I'm just shocked. And has anybody been talking to their clients about the implications?
It's divesting.
It's
It's not
exactly.
banning. It's
Oh.
divesting.
It's divesting.
Okay.
So it's divesting, and if they don't, it's a ban,
Oh, okay.
right? And the
Okay, so
Senate is saying that they will not.
So it sounds like
decide
it's
unless
not
it's-
banned, but they have to divest from their parent company within 6 months. Okay, so
We're not there yet.
they'll probably go through the motions of doing that would be my assumption.
Well, it's a big risk.
So thank you for bringing that to our attention. I have a question for the audience. So we talked about ambush marketing, dark patterns, influencer marketing. Are there any hot topics that we didn't cover here today that are important in your country? Yes?
Yeah, I just have like a comment or question.
With micro.
Oh.
Yeah, it's just like a comment or question. We see all these cases and they are like about these big companies. But I've been sometimes in contact with like small businesses and I feel that they might not be aware about it or they're maybe don't consider relevant. I don't know if there's like a threshold or like what companies actually the regulators kind of call to action or like they call attention about like advertising issues. But I think that maybe small businesses also need to be aware about that, and I don't know if there's like a focus about it. I feel like there is something missing, at least in the US, at least in New York, because I have counseled some clients and I tell them like, you need to put this or that, but they don't think like it's relevant. They say like, people is not gonna pay attention. So it was just like, that was my comment.
I think that's probably a universal problem, that if you're a small enough company, you think you can fly under the radar, so you don't comply with the law. Now, how many people in this room have that issue with your smaller clients? They say, the FTC, the regulators, they don't know me, I can do whatever I want. I don't think that's specific to any country, but you know, when you do start seeing regulatory actions, what we usually do is say, okay, they came after this company. I mean, the warning letters went after a company that was, you know, not as a trade association. They're not even like a big brand like McDonald's. And you can use that as an example to say, okay, they went after a trade association. The FTC a couple years ago went after a small agency in Georgia for violations of the FTC endorsement guides. Show them examples of that and say, you could be next, even if you think you're flying under the radar, because you don't know how these cases fall into their laps.
I have a comment, and it happens a lot to Latin clients. So at the end, yes, the Latin clients, until they have an issue, then they want to hire you. So it's a little bit about education. So you have to educate them, educate the clients in a day by day, but until it hits in the wall, then that's when they start talking to you, because they don't want to spend money. But I think it's imagine in IP it happens. Now in advertising, that's the second instance. So it's about education.
Any other questions?
Hi, I'm on the Germany termination rule. How do you authenticate? Like, could somebody just hijack an email, submit, and they're out? And are you able to text back, do a code, confirmation code, any type of communication? This, I work, opting out or this is a, termination is a higher level of opt-out, so wanted to ask about that.
Well, it's indeed final. Yeah, that is actually exactly the point why this rule has been criticized a lot, because it could be hijacked. Somebody else could terminate your contract, but then the question is, why would somebody do that? So it obviously doesn't happen that often. There has been no issue. I haven't seen any comments on that. It's just been in the commentators. They talked about it and criticized it for that reason. But then, of course, if you as a customer see that your contract has been terminated without you doing anything to it, then you can immediately go back to the seller, obviously, and say, hey, listen, that wasn't me. I want to continue, because no seller would say, hey, you have continued, unless their prices have gone up a little. And,
So Stacy, we have 4 minutes. Any last questions? Everybody want to go to lunch?
Thanks,
Okay.
everybody. This was great. Thank you all for being here.